Hey everyone, Harry here to talk about the Supreme Court's denial of Jack Smith's motion for certiorari before judgment. Okay, let's break this down because it's precious little information to go on, but I think we can make some educated surmises. First, just to review the bidding a bit. Jack Smith, after Judge Tanya Chutkan ruled in his favor on immunity, but then that gave Trump an automatic stay on the reasoning that immunity is a right to be free from the rigors of trial and discovery in the first place. So if you lose immunity, you can take an interlocutory appeal up to the Court of Appeals. And also, Chutkan ruled in this case, rejecting Smith's position that everything had to freeze in front of her. She couldn't, as Smith had suggested, keep going on with the pretrial proceedings and motions, which would have had the effect of not necessarily delaying the whole trial and the beginning of the trial. Because she didn't do that and she stayed everything, basically every day now is a day later that the trial can begin. So in that sense, from the start, this was a victory for the Trump delay strategy and his sort of big play in delay maneuvering, because it's the one motion that is a little bit meaty and might require Supreme Court review, but more importantly, gives him this automatic stay. Okay, so at this point, Smith came in and did a really rare move, and I thought a smart one, asked the court to take the case right away, even though the Court of Appeals hadn't ruled yet. That's something that court rules provide for in important cases. And it's been done rarely, but this Roberts Court has done it with some regularity. So it was saying, look, this is a really important case, which is the basic criterion for having the court take it quickly and jump the gun, leapfrog over a Court of Appeals opinion. And in fact, the court sort of hopped to right away and issued a schedule for Trump to respond to this motion to take certiorari right away. And they moved on it really quickly. In fact, so Trump did his response, and Smith within 24 hours did a reply, and that was yesterday. And the court today said no. Bit of a buzzkill after all that had happened, because people were anticipating A, that the court really is going to have to decide this, and B, it could happen soon, and we would still be looking at a pretty early trial date, not the March 4th date, but not losing too much. All right, but the court instead said, simple order, the petition for certiorari before judgment is denied. What happened? Here's what I think happened. There are some people out there saying, oh, Smith didn't really make the case of how important it was because he couldn't say expressly that the election is coming and we have to decide before that. I don't think that is it at all. The court is very, very aware both of the importance of the issue and of the need to move quickly. But in the interim, after Smith filed his motion for cert before judgment, the D.C. Circuit, which remember had gotten the case, Trump had filed a notice of appeal as soon as Chutkan had ruled against him, but it was just pending there, and cases on appeal often take quite a long time, a year or more. But here, the Court of Appeals also hopped to, and on its own motion, it issued a blazing fast briefing schedule and oral argument schedule, and everything is going to have to be briefed by, I think, January 2nd, and the oral argument here is January 9th. And it could well be that they issue an opinion very shortly thereafter. I wouldn't be surprised if the presiding judge already is writing things up. So it made it clear that they were going lickety split. Why did that matter? Because for the court, it was looking at the prospect of taking this case now or waiting 2 weeks, 3 weeks, until the Court of Appeals had made its decision. Court always prefers to have a good ruling below from the Court of Appeals, maybe even a dissent, to have both sides. I was a clerk at the court and wrote many memos to the court giving advice on whether or not they should take a case. And that factor, a good opinion below, is really important to the court. So I think the big point that happened here is between the time that Smith said, take this right away, and the court immediately said, okay, we'll think about it, and here's our fast motion. The DC Circuit had made it clear that they were going to go really quickly, and the court just had to wait a few more weeks. It's also, I think, significant and some evidence along those lines that it was just a simple order with no dissents. The court here is painfully aware, too painfully aware of the pressure it's under, the possibility that it intervene in the election in a way that would dispense even more of its institutional capital, aware that it is kind of in low regard, especially with some of the ethical scandals. And I think all members of the court, if they can, on both sides of the aisle, would really like to avoid further wounds to the court overall. And that would be what the Chief Justice is trying to accomplish. So I think they get together on this petition from Smith, and they see a way that they can coalesce around a particular result. And they're aware, as I say, and they will be aware. This is something to take stock of. They'll be aware going down the line of the kind of realpolitik that these cases present and how it puts them in the sort of, eye of the hurricane. So all 9 of them could come together with the notion, let's wait for the DC Circuit. It'll just be a few weeks. And they agreed on that, and they could issue a ruling that didn't have any dissents, didn't have Alito and Thomas complaining about the court conduct, didn't have Kagan or Sotomayor or Jackson saying the same, and just was a simple court is together for today on this motion. What does it mean going forward? I don't think it's any indication, for the reasons I've said, that the court doesn't intend to take up the case, doesn't realize it probably needs to resolve the issue and do it quickly. I think what it means is they can wait for the DC Circuit to issue its decision, which it will probably do, let's say, mid-January. Now, normally what would happen then is Trump would have 30 days to ask the full court en banc to review the decision, assuming he loses, which I think he will. Then he'd have up to 90 days to petition for cert. So he'd be able to eat up all the time he needed before November. But the Court of Appeals, like the Supreme Court, is on to him, really aware of his delaying tactics. And they have a fairly straightforward way, I think, to keep him from eating up all the time on the clock. And that is, they can issue their ruling and stay it, but for a short time, say a week or 14 days, at the end of which the stay would dissolve, meaning that he automatically, if they had held against him, would not have immunity, and Chutkan could go forward. That would pretty well force his hand to petition the court quickly, or even at that point, Smith could move again for the court to go immediately and grant a petition somewhat prematurely. But if it's the 14 days, it would force Trump's hand. At that point, once petition's filed, the response can come in anytime. You can just boom, do it. And the fact, by the way, a sort of aside here, after Trump's response, I said the DOJ took 24 hours to do a really solid 10-page reply. And that's because they now have on the job one of the best criminal law advocates before the Supreme Court of his generation, a guy named Michael Dreeben, who was recruited from the SG's office to Robert Mueller's office, and now is in the office of Jack Smith. In any event, they can, once Donald Trump does a petition for the court within a short period of time, they can immediately come in and we're off again on a very short timeline. If you do all that computation, we've still lost a decent chunk, say 60 days, maybe 90 days. We're still looking at a early summer trial. And by then, of course, it's quite likely that Trump would have sewn up the nomination. And yet there's still plenty of time to go to a jury conviction or not, go to a jury resolution well before the November 2024 election, so that the American people have the possibility of, have the knowledge of whether one of the presidential candidates is a convicted felon or not. And I think the court will be eager not to be the force that gets in the way of that happening. So they'll be focused on, if they take the case, and I think they will, focused on the timeline. And we'll talk about it then, should it happen, but I think also likely to rule against Trump and permit the trial to go forward. Once that happens, now Trump has played his big card for delay, because the other moves he can make are just in front of Chutkan. They don't get interlocutory appeals, meaning she can deny them or make quick work of them and not have them eat up the clock even more. So if a new date is drawn for, say, early summer, she'll have the ability to enforce it and keep it from slipping much further. So that's the bottom line. The court's unanimous denial of Smith's motion is really because the D.C. Circuit's about to decide it, and it could well mean it in no way forecloses the ability of the court to decide it soon after the D.C. Circuit and to both take the case, decide it, I would think, against Trump, and do so quickly. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.